Hello everyone. Very good evening. I hope I'm audible. We'll start our session in next 1 minute, okay?
Yes, ma'am.
Okay, so let's begin with our session now. Can you please mute your mic, Mohammed sir? I have a request to everyone. Please mute your mic when I will be teaching you, okay? It really creates certain type of disturbance when I am speaking. Okay? So very good evening again to all of you. Today I'll be dealing with your second draft that is known as written statement. Okay? So I'll share my screen so you all can see the draft of written statement. Okay. I hope my screen is visible with everyone.
Yes, ma'am. Visible.
Okay. Thank you for responding, sir. Okay. Now let's start with what is written statement. Okay. Then we are going to see how the formal portion of written statement has been presented. Then what is a body of a written statement. Then we are going to see how to draft this written statement. Okay. So there are total 5 pointers which you need to follow when you are drafting a written statement. Okay. Then even when you are drafting a reply of written statement, and there are certain important considerations. Okay. And even I'll be going to give you certain case laws, so that will be helpful for you to understand how you can draft a written statement. And then we are going to see this structure depending upon the pointers which I'm explaining. Okay. So before I go ahead, how many of you know, or you at least have a general idea what is written statement? So those who know about what is written statement, please
Reply to the
explain
plaint.
your. Sorry, sir.
Reply to the plaint.
Okay, different reply. Okay, anything else? Anything
Counter,
else or
counter,
any
statement,
another?
counter statement for the plaint.
Yes, right. Yes. Okay, thank you, sir. Any another person is having any answer? Any different answer? In general sense, okay, you can give your answer. It's not like what is given in your book or where you have find out any definition or. Just tell me your understanding regarding to written statement. If you know about what is written statement. Yes, anyone?
Ma'am, acceptance and rejections of the for the plaint.
Okay, okay, yes.
It is the explanation for the plaint, whatever is the
Yeah, I
complaints
think
or
this is
whatever.
Vinitha, right?
Yeah.
Yeah, yeah. In general sense, your answer is correct. And even Rafi sir also correct. All his 3 answers. Hmm? So basically, let's see what is this written statement. Okay. And if there are certain important terminology, I'll put those terminology in chat box. Okay. So first of all, try to understand what is this written state. Before I go ahead with this draft which I have presented in front of you. Okay. So basically, whom is needed to file this written statement? So written statement is required to file by defendant, and it is nothing but it is an answer to the claim which has been made by the plaintiff in his plaint. And where also we can say that where it has been delivered to the defendant along with the summons to attend the first hearing of this. Right? This is what both of you have stated right now. Right? Now, when we are dealing with the written statement, it is a statement or it is a defense of defendant by which he either going to admit the claim of the plaintiff or he denying all the allegations or averments which has been made by the plaintiff inside of his plaint. Now, inside of this written statement, it specifically deals with the allegation of the facts in the plaint. I hope you all are agree with this, right? On what we are going to give this written statement, of course, the facts which has been stated by the plaintiff inside of his plaint. On those we are going to file, or where specifically we are going to deal with the allegation which has been made by the plaintiff. And when a defendant in this instances he is denying any fact, he must not do is that person whoever is the defendant, he must not be do it this evasively, but the answer should be there same in the substances. Why? In general term, I'll tell you. Before you go ahead with the proceeding of draft of this written statement, you should understand the necessity for a pleader. What is necessary, you being a pleader, for making this draft? So what you need to do at the first instances? First, you need to examine the plaint very clearly, right? Because this is a written statement which you are returning in form of what your defendant feels and what allegations you are going to deny or you are going to accept, right? So for that, first you need to examine your plaint very carefully. And you need to see inside of your plaint which you have been seen whether whole information which you require is fully understanding, and even the claim which has been made they are drawing up over there or do not. It's like defenses are available or not inside of the plaint. Now if any particulars you wanting over there, so you should apply that the plaintiff be required to furnish them before the defendant files his written state. These are the things included when we are dealing. Now let's say that if he cannot make a proper defense without going through such a particulars, or whatever documents were given, you have not referred such documents which are given in the plea, then the defendant is not in possession of such copies, or even copies does not going to serve the required purpose of it. So when the defendant should call upon the plaintiff to grant him the inspection of all of them, and even that person needed to permit to take the copies if necessary over there. And if also you being a defendant you think that these are the documents which are given by the plaintiff, those are really necessary, so even you can apply for discovery of the documents. This is a right which you have being a defendant. And if you think, okay, if your client think that allegations in the plaint are embarrassing or they are scandalous, you should apply to struck it out, so that you may not plead for those allegations if you're not agreeing on those. If there are several defendants, so they are going to file a joint defense. Okay, they say that inside of this draft, there are several defendants, defendant number one, defendant number two, defendant number three. What they can do? They can jointly file their defense. And if they have the same defense to claim, means let's say that if I have written over here, suit for rejectment and arrears of rent in the small cause court. Okay, if arrears and rent is there with many of the defendant, those who are resident of that society or of that fact. So of course there will be all the defendants from that flat or from that society whose claim is same. Okay, so they can file this written statement jointly. Okay, if now in second instances, if their defense are different, they should file a separate written statement. Okay, and if the defenses are not different but they are conflicting, so it should be, or it is not proper for the same pleader to file the different statement. Okay, I'll give you one example. So by that you will get the idea why I'm talking about this. Okay, let's say that if two defendants or executants of a bond, okay, are sued on the bond which were there. Okay, so their plea is of one of the satisfaction, right? So here the main thing that is bond. For both of them, bond is one on which the claim they wanted to do. Okay, so what they can do, they can file a joint written statement. If in certain types of cases the plaintiff is claiming the limitation, like from the date of certain acknowledgement has been made by one defendant, and uh, they are contending that the acknowledgement have been saves their limitation against the other also. So here what a defendant can do, the defendant may file a separate written statement, right? So what you need to do, you whenever you are finding out that there are certain conflicting interests inside of it, when it has been done jointly, so don't do it jointly, keep a separate. Okay, file a separate written statement in certain types of cases. Now next thing is if there are any suit of mortgage. Okay, so suit of mortgages was for a legal necessity. If sons wanted to deny that whatever they have alleged regarding to the legal necessity, they should not only file a separate written statement or defense from their fathers, but they should also preferably engage a separate pleader also. They needed a separate pleader when they are dealing with certain types of mortgage cases. Okay, so this is there regarding to the general understanding of written state. Clear everyone? Any question do you have? Yes? I hope you all are hearing me.
Yes, ma'am, we are hearing.
Can you
Can
give
you?
one more
Yes,
example?
you are audible.
Okay, yes.
One more example, if you could, please.
Yeah, I'll give you one more example.
Ma'am, I have a doubt, ma'am.
Yes, sir.
Can
Go
you
ahead.
can you once again can you tell me about engagement of more than two plaintiff or two defendant?
Yeah, I'll give you those. Okay. First, we'll clear Vinta ma'am's doubt and then next your doubt. Okay, sir?
Okay, ma'am. Okay.
Yeah. See, written statement is something where you're going to give a reply, right? Now, I gave you example of mortgages and even a bond. Okay. Now, as you can see here, the suit for rejectment and arrears of rent. Of course, we know that what is arrears of rent, right? Now here, if your defendant have failed to pay arrears of rent, okay? Now here, if he is failing, so what are the things on which you are going to plead in front of a court? So that will be a written statement, okay? Because this is something which has been claimed by a plaintiff and you are a defendant over here. So as plaintiff is filing a claim, you being a defendant, what you can file? You can file a written statement. This is what is there regarding to a written statement. And when number of people increases inside of this written statement, let's say that as I have talked about the arrears of rent again, This is something which is there regarding to the society. Okay, assume that this is regarding to society. Now let's say that if me, Rafi sir, and Vinita, we all are staying in one society. Okay, here one problem is I am having suit filed, that is arrears of rent. If I am not able to pay my rent, there are certain problems or allegations on which I wanted to file a different written statement. Why? Because cause of action or the main specified area where I am not satisfied on those allegations, I am going to file it. That's why I'm going to file a separate written statement. I will not file a joint written statement. If our three of us motive is same, me, Rafi sir, and Vinita, if three of us motive is same, like we don't want it to pay the rent because we have not given certain types of amenities by our society, so then we can file it jointly. But when our causes, if our problems are different and even our allegations are also different, so we are going to file it separately. This is what is there regarding to return statement. Got my idea now, both of you?
Yes, yes, ma'am. Clear, ma'am.
Great. Okay, Vinita?
Yes, got it.
Great, great.
Brilliant.
Okay, now we are going to see a written statement in a form of drafts. Okay, so when we are going to deal with the formal portion of draft, okay, so we are going to understand how we need to make a formal portion of written statement. Okay, if you are noting it down, please write it down in your notepads or your notes if you are writing it. Okay, now first, what is formal portion of a written statement? Now, as you can see over here, as you all have seen the plaint, so written statement should also have the same title as the plaint, like how I have given: suit for rejectment and arrears of rent in the court of small cause, Mumbai, suit number 236 of 2023. What is this? This is my heading and title. And if there are several plaintiff or several defendant, the name of only one may be written with the addition of and others or others, as I talked about this before also. Right? Now let's say that AB son age resident who is a plaintiff versus again one name will be there and others. This we are going to write inside of our name of the parties. Okay, so where you use a words like and others, as the case may be, regarding to the scenario. Okay, so next thing which should be there, that is the number of suit. As you can see, suit number. The number of a suit should also needed to be mentioned after the name of a court at the center. Right? Then after the name of the parties before the actual statement, there should be um, added some words which are indicating whose statement it is, right? Whose statement it is means the affirmation which you need to do. So, for example, written statement on behalf of all the defendants, or written statement of behalf of defendant number one, or you can write written statement of behalf of the plaintiff in reply to defendant's claim for set off, or written statement or replication of behalf of the plaintiff filed under order of the court dated. You need to write a date if certain are there. Next is written statement on behalf of the plaintiff filed with the leave of court. The words the defendant state or defendant state as follows will be used before commencement of their various paragraphs, like how I have written over here: written statement for ejectment of arrears of rent and mezz profit, the above named defendant stated as follows. What is this? This is my affirmation when I am dealing with the formal portion of it. Okay. Now, one thing you should keep in your mind when you are dealing with a written statement, that is, there are no relief should be claimed in the written statement. And even statements such as where the claim is liable to be dismissed, certain types of things should be avoided when we are dealing with the written statement. Okay. But when you are dealing with a set of, So set off is pleaded, or here the defendant prefers the counter claim for any excess amount which is due to him. And even at last, what you need to do, at last, you need to make a prayer for a judgment, for the amount in the defendant's favor should be made. I plead to this court. That's why we need to make this prayer under written state. This is there with the formal portion of it. Now let's understand what should be there at the body of this plaint. Okay. Now, as I'm writing the above named defendant state as follows, now my main body portion of this written statement starts. Okay. So here, what is happening when we are dealing with the body of a written statement? So rest of whatever things are you are going to mention inside of your written statement, it should be confined only and only of the defense. So there are certain forms of defense which you need to make when you are dealing with this written statement. So maybe your defense may be in the form of a traverse. What is traverse? Okay, I'll put this pointers in your chat box so it will be easy for you to understand. Okay, now I took this name, traverse. What is traverse when we are dealing with it, or when we are going to make a defense? Where a defendant is totally and categorically denying the plaint allegation. Okay, he is totally denying a plaint allegation when I am talking about the traverse. Second instance that is there regarding to the a confession or avoidance. Now, when we are dealing with the confession or avoidance, it is something which is there regarding to when your defendant admits the allegation, but he seeks to destroy the effect by alleging it affirmative. So, by doing this, adding his own certain facts, and where your defendant is also admitting the bond in a suit on which he is going to plead that it has been paid up, or the claim is having a bared limitation, right? Where first instance is either he is making a confession, or second thing, either he is totally avoiding what are the claims which has been made by the plaintiff. So whatever it is, don't confuse it when you are drafting your written statement. Keep it clear. If it is in confession, if you are agreeing with the terms, if you are agreeing with all the allegation which has been made, then you need to write in that way. And if there are certain avoidance, then you need to go ahead with the avoidance. Or if there are certain parts where you are accepting those allegation, you need to make it different, like point number 1, 2, 3, 4. Don't mix with at certain cases you are making an confession and you are accepting those allegations, and certain things you are avoiding it again. So it should not be mentioned. It creates your draft so vague, and even the person in frontier who is going to give you answer to your written statement, it also get confused for that. So he don't even give more focus on what should be have taken into account. Okay. Now third point is there regarding to an objection in point of law. Very important. Okay. So an objection of point of law from which a right has been came, or this is a part of which law? Actually, this is a part of common law. It has been started from the England. And also, there is a term called as a demurrer. Okay. This is there in one of the famous drafting book by Moga also, and even there is one more author. I'll give you the names of this author also. There they have written a demurrer. Who is a demurrer? Okay, I'll tell you who is him, and from a point of view of a draftsman, what this is. Okay, I'll give you one example by this terminology. Okay, that where the plaint allegations does not disclosing the cause of action. Okay, what I'm saying, where the plaint allegation are does not disclosing a cause of action, or there are certain things where the spatial damages has been claimed, and this spatial damages which has been claimed by the person in front here, they are too remote. Now what needed to be done where we are dealing with certain types of, now at certain types of point there will be another plea may sometime you need to be taken which merely delays the trial of the suits on the merit. Now how this is happening, let's say that a plea that is having the hearing which has been stayed according to section 10 of civil procedure. Okay, so where they all are talking about the formal portion of it, where they are stating that the suit has been not properly framed. There have been some of the defect in the joinder of the parties or cause of action where the cases cannot be decided until those defects have been removed. This is what they talk about. Now, this is what is an objection in point of law, where the objection has been made on the representation of your draft. And this has been done according to section 10 of Civil Procedure Code, where your written statement can be sent back to you. Then you need to make the given changes accordingly by the court with the discretion of it. And then again, you need to resubmit it to the court. And then only it will be accepted by the court of law. It means you're going to remove all the defects which was there, and then you can again give it back to the court where first the suit has been entertained. This is what is there regarding to the an objection in the point of law. Okay, now next thing is deal with the pleas in the bar. Now what is pleas in the bar? Now there are certain types of dilatory pleas. Okay, this is one of the type of pleading. So these are the dilatory plea. I'll tell you what are these dilatory plea, but first try to understand what. Dilatory pleas are not permitted in pleadings. Okay, but when we are dealing with the dilatory plea, they must be taken by the separate proceedings. Why? Because other times either they have been taken in the written statement under the headings of preliminary objections. Okay, they has been taken into account when there are certain preliminary objections. You needed to give this title when there are pleas in the bar, or you need to make an separate application to file at the earliest opportunity. Okay, it's like where you are having the misjoinder or non-joinder, or it's something which is regarding to where you cannot be permitted unless it has been taken the earliest opportunity, means when you have given the opportunity to ask for whatever claims which has been made. And there are certain objections which are totally preliminary over there, and there are certain misconception regarding to your misjoinder, regarding to your non-joinder. Then this plea in bar needed to be made under the title of preliminary objection which are there. Okay, so this is there regarding to the body of your written statement. Understood till here, everyone? Yes.
Ma'am, once again, can you tell me about preliminary objection?
Yeah. Yes. What do you understand by the term or this word preliminary?
In
Have
the
you
beginning,
heard this before?
yes, ma'am, yes, ma'am. In the beginning, earliest.
Right. So are you a practicing lawyer?
No, ma'am.
No. You are a student, sir?
No. Just I have completed. I'm staying home.
Okay, just here come. Okay. See, preliminary objections are nothing but they are the key issues inside of your case. It's like, where I am directly pointing out on where this defendant should not, like, where this defendant is pointing out why there is a lack of jurisdiction under this, why there are certain things has been made by you. Means directly you are asking the question. Even if I talk about it is something where you are taking a step. When a response, it should be dealt separately or it should be dealt jointly. Okay, so it is regarding to the issue which has been arose over there, and on that issue you are asking certain types of question, or you are raising certain obligation, right? You being a defendant, there are allegations made, right? So you are not alleging with those where you are directly objecting to the what counter things has been made on you. And when you wanted to make this objection, it must be made before the date for the filing of your respondent's counter memorial. This is known as respondent rejoinders, which I was right now talking about. Okay, here there are certain additional facilities has been given by ADR. Okay, even these facilities has been given by civil suits also. Okay, understood till here, everyone?
Yes, ma'am.
Okay, try to understand what is preliminary answer inside of this. It is nothing but it is like a initial response which I am giving to you. It's like the information is given by Rafi sir to me. Okay, it's like data I have collected from Rafi sir, and after collecting that data I am analyzing it, and then I am giving my answer on it, and then I am also asking certain question on it inside of my written state. Okay, now I hope you got the idea clearly, right, everyone?
Ma'am,
Yes.
can you repeat?
Yes, sir.
No, can you repeat?
Yeah, I'll repeat it for you. See, sir, try to understand this. Okay, I'm talking about preliminary answer over there. Preliminary objection you have seen, but first you need to analyze what should be the answer, right? So what have happened? Let's say that he, when I'm dealing with the preliminary answer under my civil suit, so what will be there? It will be like here I am thinking on, or I am giving the initial response to you, initial response to Rafi sir. So on what basis I am giving this initial response? It's like inside of his plaint he have given all the data. And if I needed any documents, I will ask him to please provide me these documents through my lawyer. So what it will be? It will be like information and data which I am collecting from the person. And after collecting all this data, I'm going to analyze it. Means I'm going to analyze my plaint, and then I will see what allegations have been made. And then I'm going to ask questions to you, question to Rafi sir, on what basis you have made certain types of allegation, and this is what I'm stating inside of my written statement, जिसे कैफियत कहते हैं in Hindi. Okay, when you will practice in Marathi, it is called as lekhi kaifiyat. In English, it is called as written statement, and in Hindi, it is called as kaifiyat. It means I am giving my kaifiyat ka application, that is, I am giving my written statement application to the court at my first instance. Understood now?
Yes, ma'am. Clearly understood.
Great. Okay. Now let's talk about how we need to draft a written statement. What are the main objects where we need to see? First thing on which you need to be rely, or which you need to be focused, that is denials. I hope you all are agree. Why denials? Why we make denials? You all tell me. Why we all make denials?
Because it's a written statement.
Right, because it is a written statement, right? Yes, Rafi sir, you have any answer?
No, ma'am, same answer. I agree with that.
No. Okay, okay, same answer. Okay. Hmm? I hope others are also listening, right or not? Simran, Nikhil, Subhash, Maitri, Siddhi, Pushpendra, Ayushi, Adarsh, Ghazal. I hope you all are listening to me, right? Okay. I am able to see
ma'am.
thumbs up. Okay, okay. Now let's understand what are the denials. Yes, thank you for giving your response now. I got it. You all are here. Okay. Now, what are these denials over here? Denials are nothing but where a defendant is saying that he need to take the defense of denial when he is totally or categorically denying on the allegations which are there inside of your complaint. Of course, in general sense, right? As I have talked about the traverse. Traverse is nothing but where there are admission of the denials. It is there regarding to the material facts which has been alleged inside the plaint, which has been submitted by the plaint. And it should be always given in the opening of the paragraphs of your body of a written statement. Please try to understand this. Okay. And what are the rules of denials you need to follow? First thing, denial should be a specific denial. And your denial should not be the evasive one. Otherwise, it's create a chaos inside of your draft. So don't keep those evasive drafts over there, or don't make certain type of evasive denials inside of your written statement. Okay. Next is there regarding to the dilatory pleas. What are dilatory pleas? Where these pleas which are merely delay and the trial of a suits on which merits have been characterized. These are nothing but these are the dilatory pleas. Okay. Now these dilatory pleas are nothing but they are raising the formal objection to the proceeding, where uh, there are certain substantial reply needed to be made when there are certain merits of the case which you have found out. Now let's say that the plea under which the court fee paid by the plaintiff is not sufficient. Okay, the court fee which has been paid by the plaintiff is not sufficient. So what this will be? This plea should be raised at the earliest opportunity that this person have not paid the court. So this will be a dilatory plea. And next thing which I have talked right now, that is regarding to the objection to the point of law. It means like you should not make certain errors when you are dealing with your draft, and where you are going to have a legal inference in which the plaintiff claims have been given. Okay, so you need to make certain allegations where your defendant going to say those allegations on which the facts were involved regarding to the case. Okay, and it's supposed to be the correct one, not it should be the materialistic one where you have adding all the mirch masala and then you are representing. They are not at all entertained in the court of law. Okay, these are the three main things needed to be mentioned or needed to be kept in mind when we are dealing with this. Okay, now we are going to see the draft of a written statement which I have made. I hope the screen is visible, everyone.
No, ma'am.
Now,
Now it's gradually it's opening. Now it's okay.
okay, okay. Okay, now let's see how this written statement has been made. Okay, as I have given you instances while explaining the terminology also. ठीक है. So basically this written statement has been made suit for ejectment and arrears of rent in the court of small cause and the jurisdiction I need to write. Either it's Mumbai, Pune, Kolhapur, or whatever area it is. It has been done in Hyderabad, Bangalore, Andhra Pradesh, where it is that you need to write. Then suit number of year, and then again, as yesterday I talked about, you need to keep some space for court fee stamp. Okay. Then we are going to write the name of the parties. If there are more than one or two plaintiffs, then 1, 2, 3. Versus if there are many of the defendants, then you're going to write one name and others. Like PQ, son of RS Edge, resident of, let's say that's Shiv Society, then and others. Like this, you're going to write if there are many of the defendants are there. And if single, then only one name. Okay. Then we are going to make a affirmation. The written statement for ejectment, arrears of rent, and measly profit, the above named defendant stated as follows. Now, what the defendant is going to state. First, what we are going to start, that the defendant admits the fact stated in paragraph number 1 of the plaint. Now, what we are doing, first we are admitting what is there inside of paragraph number 1, which is there inside of a plaint, right? Because this is a reply to a plaint, right? Second point, that the defendant admits the agreement mentioned in paragraph number 2 of the plaint and his occupation of the said house as alleged there. Again, in second point, he's admitting what is mentioned in the paragraph 2 of the plaint. Now, in third point, that the defendant denying on something, that he has not paid the rent from June 1, 2023, as stated in paragraph 3 of the plaint. Right? Now, here he is denying on certain points. So, these are the clear one, where he is admitting, where he is denying. Okay? Now, let's go ahead with the fourth. That the defendant admits service of the notice alleged in paragraph number 4 of the plaint, but does not admit that the plaintiff duly determined the defendant's tenancy thereby. That the defendant admits that he continues to be in the occupation of the said house, but denies that he has not paid any part of the said arrears of the rent, or that he is liable to ejectment under the provision of law alleged in paragraph 4 of the plaint. So clearly here we are stating on which point we are going to admit and on which point we are going to deny, right? Now, depending upon the same, that the defendant does not admit any one of the several allegations made in paragraph number 6 of the plaint. Means whatever has been given in that paragraph number 6 of that plaint is not at all admitted by the defendant. That's we are going to write. Now, again, we are talking about para number 6, that no cause of action even occurred to the plaintiff alleged in paragraph 6 of the plaint. Of course. So, as apply your logic over here, we are only stating where we are admitting and where we are not admitting, right? And here we are directly stating on the point which are main body of our draft, or main body of our allegation. That is cause of action. Now, in whatever paragraph it has been given, you need to write, I am not agreeing with what has been alleged in the cause of action. So where it has been mentioned, it has been mentioned in paragraph number 6 of the plaint. Right? Next thing is that the defendant admits the jurisdiction of the court as alleged in paragraph number 7 of the plaint. Right? Means he is admitting the jurisdiction, means of course the place and the area will be the same. Okay. Next thing is that the paragraph 8 of the plaint relates to the valuation of suit and payment of court fee. Okay. Here he is agreeing to pay whatever has been given by the court. And if there are any additional fee, he is ready to pay on that. Now, what are those additional fees that we are going to see? Ninth, now we are coming to the main part of it, that the defendant has paid the rent for the month May, June, July, August, September 2020 to Shri EF, who is the plaintiff. The plaintiff authorized agent who has been collecting the rent of the said house on behalf of the plaintiff, but no rent received in respect of the aforesaid months have been issued by the defendant. Right? Now here the defendant is pointing out he has done his part, but whoever was the principal agent over there or authorized agent over there, he has not performed his duty well. Even if he has been paid all the things, he has not given the receipts. So here lack of the services has been seen. So on that they are saying, and here the description has been given. Right? Here clearly it is stating that a defendant has played his part, but they don't have any receipt to show that he has paid the money. Right? Now next thing is that the rent for October 2023 and that for the subsequent months was tendered to the sent agent of the plaintiff and to the plaintiff himself, but both have refused to accept it. Right? Now when he was giving what they did, they have refused to accept it. Right? Now this is also mentioned. Next thing is that in fact only rupees dash, now whatever rupees has been there, let's say that 20,000 or let's say that 5 to 6,000 are due from the defendant to the plaintiff at arrears of the rent, being the rent for the months mentioned in paragraph number 10 above, and that the defendant is ready and willing to pay the said amount to the plaintiff. Right? Now whatever amount has been due here, the defendant is ready to and willing to pay it, but what he needed the receipts of it, where he should have a proof that I have paid. Right? Clearly it is indicating that. Now 12th is that the notice mentioned in paragraph number 4 of the plaintiff is invalid in that, and it did not purport to give sufficient period of time of the defendant as stipulated in section 30 of UP Act number 13 of 1972. Like how we have in Maharashtra Rent Control Act, where if there are any arrears of rent are there, we are following section 23 of Maharashtra Rent Control. Now this is a matter which has been happening in UP, so of course section 30 of this will be applicable regarding to the state acts. Okay, and at last that there are absolutely no grounds for granting the relief prayed for by the plaintiff, and the suit is liable to be dismissed with the cost. Okay, then what we need to do, we need to write the place, we need to write the date, and at the right side there will be name of the defendant, then sign of the advocate, and name of the advocate should be there. Through advocate, name of the advocate, and sign and stamp. Okay, and last we need to make the verification. This should be done by the defendant. As in a plaint, it should be done by a plaintiff. In written statement, it should be done by the defendant. I, AB, he aforesaid defendant do hereby verify that contents of paragraph 1 to 1 and 13 of the above plaint are true to my personal knowledge, and the contents of paragraph 1, 2, and 13 I believe to be true on information received. Signed and verified this day, let's say that today's date, okay, that is February 13, Tuesday of 2024 at Mumbai, again signed of the defendant. By this, we need to make the draft of written statement. Now, do you have any doubt regarding to this written statement draft? Yes?
No, ma'am. No, ma'am.
Clear with everyone? Okay, I can see thumbs up. Why you all are so silent? Are you lawyers or not? You know, lawyers should be more eager to speak. You guys are so silent. Okay.
Might be
Okay.
10% concentration, ma'am.
Sorry, sir.
Might be 10% concentration.
Oh, okay. This is an
Equally a good listener as well.
yeah, okay. Now you're giving your general defenses, right?
We are proving.
Okay. That's nice. That's nice to hear. Okay. Okay. So as we are done with the written statement, Okay, so I feel that we should start with our next draft as there are only 10 minutes left. I'll give you certain information regarding to it, and tomorrow we'll see the briefing of it. Okay, so as the case, as we are done with the plaint and then we are done with our written statement, I'll give you the idea of what is affidavit. Okay, so do you guys know what is affidavit? Have you heard about it? Yes.
Yes, ma'am.
Yes, can you tell me, sir, what is affidavit?
So, see, what are the points are there in the written statement has been written on the affidavit side and given signature in the form of affidavit.
Okay, okay.
For legal acceptance, ma'am.
Legal acceptance, right. Yes. This is nothing but that is the legal acceptance. Okay. So I'll show you a draft of affidavit, and then from tomorrow we will start with the contract drafting. Okay. So we will going to see leave and license agreement at first. Okay. Then I'm going to show you the e-services, e-contract, electronic contracts. This three terminology will follow from tomorrow. Okay. Is it fine with everyone? Yes.
Your screen is not opening, ma'am.
Oh, no, no, I have not shared my screen till now, sir. Yeah. This affidavit draft I'm going to share on your WhatsApp group after completing this session. Okay. And from tomorrow, what I'm going to start, that I'm talking about. Okay. So what we are going to see, we are going to see leave and license agreement. Then we are going to see there are sales of goods and services agreement and electronic contracts. These three things we are going to cover tomorrow. Okay, because their essentials are quite same. What things should be mentioned inside of it are those are also quite same. Only the electronic contract is something different, where in your module also you will find out cloud computing services agreement and all. Of the articles, what are this agreement? Okay, for that I'm talking about this. Okay. Just give me a second, I'll be sharing. Can you see my screen? Yes, everyone.
No, ma'am.
Okay, no issues. I'll share this with on your WhatsApp group. Now try to listen me. We have a very less time, na? 5. I'll take your 5 to 10 minutes. Okay, I hope that's fine with you. Okay, so basically, what are the affidavits? Affidavits are nothing but they are the statement which has been made in writing. Okay, and this is nothing but this is a oath which you are making in front of a court of law, or you are making this oath in front of the authorized officer to whom you are calling it as a law officer. Okay? That's why you need to take a great care when you are dealing with this affidavit, because it is nothing but it is an oath which you are taking in front of a court of law. Okay, now there are certain sufficient reasons which are there when we are dealing in order to any particular facts which has been, where are the facts which needed to be proved in the affidavit. Now what are those, why we are proving certain types of facts inside of it? Because affidavits are nothing but they are the particular of witnesses which needed to be read, which needed to be given at the time of hearing. Okay, and even our court is saying that it is provided that the court may order the deponent to appear in the person in court for the cross examination. Now, when you have been called for the cross examination, you needed to submit your affidavit. Now, whatever you are going to say, you are having a knowledge about it. You're going to state that you are understanding what are the facts and matter have happened. Okay, and on that you are submitting this affidavit on your behalf. Okay, now these things needed to be mentioned when you are dealing with it. Okay, now it is there regarding to rule order 12 rule 1 of civil procedure code. Okay, what are the things should be rated, or what things should be drawn up when you are dealing with this affidavit? So first point that is there regarding to it, that is not a single allegation more than is absolutely necessary and should be inserted. Means, as you have seen in a written statement, we have talked about only one allegation at a one time. Okay, so when it is necessary, you need to insert a necessary allegation when you are dealing with that. Second thing, the person who is making the affidavit should be fully described inside of affidavit. Means his name, residence, okay, uh, what is his father's name. These are the descriptionary part which you need to write. Age, jurisdictional part. These things you need to write. Next thing is it should be drawn up as a first person. Why first person? Here you will not write that my client. Here you will state that the defendant, or I name and then what have happened. Okay, how you like that? In proof of the aforesaid debt, I attach here to, means the proof which has been given to the court, I myself attaching certain types of document with this affidavit. This is what you write your affidavit. Okay, and affidavit again should be divided into the paragraphs, then number you need to mention, then if as far as possible for you, each paragraph which you are going to mention over there, it should be having a confined and distinct portion of it. And even there should be a subjected part when you are dealing with this. Okay, and it is there according to your order 12 of rule 5 of CPC. Even every place which you are going to mention inside of your affidavit, okay, it should be correctly and fully described. Okay, because to whom you are writing, or about whom you are writing, should be easily identified. Otherwise your affidavit has been returned to you, then again you need to make those work. Okay, and I hope at the starting of your drafting skills you have seen what are the skills you need to follow, you being a draftsman. First, you should be a very good researcher. Second, you should be very good observer. Third thing, you are very good at identifying what has happened. Should be very good with your laws. Okay, I know that it's not easy for you to learn all the laws at certain times, but if you have chosen you wanted to practice in civil, so you should be aware of what are the civil laws. If you are practicing at criminal side, you should be aware of what criminal laws will be present. And there are certain rules for the draftsman. You should be precise with the languages which you are using. What type of languages? Certain languages are defined, they are identified languages, because you being a lawyer you are representing it to the court of law, means it should be a precise language where the court of law is also understanding, and even your client for whom you are representing in the court of, right? I hope you are getting my idea. Yes or no, everyone?
Yes, ma'am. Yes, ma'am.
Right, now again coming to the part of your draft, that is affidavit, you need to make certain affirmations starting with I affirm or I make oath and say. Means it's like you are saying I am agreeing and this is what I am stating in front of a court. Okay, this is what is there regarding to your affidavits, and I'm going to share this draft of affidavit right now after the session. Okay, so till then, thank you so much, all of you. I hope you don't have any doubts. Any doubt is there, you can ask me right now. Anyone?
Thank you, ma'am.
Okay, till then, okay, thank you so much, all of you. See you tomorrow with our next drafts. Okay, have a very good night. Thank you, everyone.
Thank you, ma'am.
Yes, thank you, Akshay.